Good morning, everyone. I call this meeting to order. And Madam Secretary, do we have a determination of quorum this morning?
Yes, sir, Mr. Chairman, with 7 members present, we do have a quorum.
Okay, do we have proof of publication?
Yes, sir, Mr. Chairman, it was published on June 27th, 2024 in the Escambia County Sun Press.
Okay, and I need a motion for approval of minutes from the June 5th, 2024 meeting.
Motion to approve?
Second.
Motion to approve in a second. Any questions? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion has been approved. Do we have anyone to speak for the public forum?
We did receive one speaker request form, Alan Lowry. Mr. Lowry, if you could come to the podium and state your name and address for the record.
Good morning. My name is Alan Lowry. I live at 3534 Autumn Ridge Road, Pace, Florida. I just had a short little timeline to speak about this morning about just a reoccurring pattern for some contractors. July 2023, my wife and I entered into a contract with David Poole, DC Poole Custom Homes. I'm sorry, I'm a little nervous because this has just been dragging on for a while. He took the job and we started construction August of 2023. During that time, about 3 weeks into it, he said that he had taken a job as a project manager for another home builder, that he would have to dedicate less time to our project. Me in construction all my life, I own Escambia Roof Masters. We've been here 42 years. My father started it all those years ago. So during this time, all these things have just piled up on my wife and I. Just liens on our home. Our home's kind of at a standstill as we speak. We've had 3 liens put on our home, and I'm sorry, I'm just upset because it makes my wife.
I understand.
So we've been living in a camper, paying a large mortgage to a bank where a bank has a default button. That's between you and your builder. That's between you and your builder. So the builder was terminated March 2nd. He was terminated with a positive $78,000 of our money. We've been to Santa Rosa County twice about it, and they found probable cause, and we went to a hearing. But there's just almost no protection for the homeowner at times because I have an attorney. My attorney says, how do you get blood from a turnip? So, of course, the little investigator said that there are 6 people chasing him now. 6 claims. He has 4 in Alabama, 2 in Florida, as we speak. The first one that came before you guys a year and a half, 2 years ago from Gonzales, that one's being picked up federally now. So it's just an ongoing occurrence. And he's actually pulled 2 recent permits in Alabama. And that's what the continuance of mismanagement of business puts the homeowners. So he actually still owes Boutwell's Airmasters money. And on June the 11th, he sent them saying he's taking a draw from his new job in an email to Rodney Boutwell. Taking a new draw, he will pay them what's owed on his new draw, which is why he was here the most recent case. So that's really all I have to say. I just wish there was more protection for the homeowner. So thank you for hearing me.
Thank you for your input.
Mr. Lowry? Yes, ma'am. So you have filed complaint with Santa Rosa County,
Yes,
correct?
ma'am. They found probable cause. We went to a hearing, and we go back August. They gave him 60 days to pay Boutwell's and the brick mason. Boutwell's never filed a lien on us. I've known Mr. Boutwell since I was a child, so he just said my contract was with David Poole, not with you. Mm-hmm. So, and then just trying to figure out to recoup $78,000. He took an $18,000. I put the roof on myself. I paid for the material. He took an $18,000 draw from the bank for the roof that he put in his framing package that we didn't find out until we terminated him. And the bank alerted us. So, well, here's the roof draw. I said, I paid for that roof. And so, just issues like that. So, sorry, I'm just a little upset. It's just an ongoing thing.
Don't apologize.
So,
It's
yeah, thank you.
understandable. Appreciate your input. I will say, just as a clarification, this board knows that each case that we have before us, we have to handle it on an individual basis, not a necessarily reoccurring until it comes time to fine. And then it does have on there that if it is more than a first time, et cetera, that we can look towards it. Everybody knows that, but just for clarification for the public.
Well, and I will say that since there is an ongoing case in Santa Rosa, once we receive those findings, that will be brought to our board.
Right, right.
Because other jurisdictions send us their findings, those findings have to come to our board for review as well.
Right. We just can't let each individual case be slanted by a
Correct.
previous or anything, just. Okay, our status report, Madam.
So, yes, sir. We got a few things for the board. The first one is that Mr. Poole, doing business as DC Poole Custom Homes of Florida LLC, in regard to complaint number 230776 COM, his fines and restitution were paid in full. Just to jog your memory, the board decided to do a reduction in fines, and he did pay those fines. Our next item is John Bell. He is requesting to change his application for examination approval to residential contractor for examination. I'm not sure if Mr. Bell is present today, but he was previously approved for general contractor, and he's requesting, or was it building?
Board members, initially it was building contractor.
There you go.
He wishes to downgrade to residential contractor examination.
Thank you, Nick.
Yes, ma'am.
Yep.
Okay, do I have a motion to accept the request, change from from building to residential?
Do we need to take that into an application? Do we need to, can we approve that now, or do we need to move it into another section?
No, you can approve it now. It's just a request
Okay.
to step down. He did not reapply. You've already approved his
Okay.
application.
I'll make a motion to approve of the change.
All right, motion is second. Any questions? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion has been approved.
Our next item is Kenny Robinson, request to change his approval back to general contractor for examination. So his application originally came to us for general contractor, and it was approved for him to exam. Then he submitted a request to step down, and now he's subsequently requesting to step back up. Mr. Robinson is here today if you'd like to ask him any questions in regard to his request.
Any board member have a question concerning this?
Can we get an explanation as to why I'm changing?
Yeah, I think that'd be
Please.
Mr.
sufficient.
Robinson, if
Mr.
you'll come to
Robinson?
the podium, state your name and address, and
Thank you.
My name's Kenny Robinson. I live at 245 Meetson Way, Pensacola, Florida. The request is I've got some future stuff that we are going to do that I'm not going to be able to do under the builder's license, so I'm going to need the GC to do it.
Okay. I don't remember anything about the application as far as looking at anything, but we did approve for the building contractor.
yes, sir, he was previously approved to exam for general contractor.
We approved for this and for the prior one, so this was just to be reapproving what we've already approved.
I'm currently a certified registered.
Gotcha.
I'll make a motion to approve.
Do I have a second?
I'll second.
Okay, I have a motion and a second. Any questions? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion has been approved. Thank you, Mr. King.
Thank you.
Board members, we have one application for examination before you today. Mr. Bobby Brock. Mr. Brock, if you would please come to the podium, state your name and address for the record.
My name is Bobby Brock, and address is 7545 Helms Road, Pensacola, Florida.
Mr. Brock comes before you today. He is applying for the residential contractor examination. This is a continuation from the prior hearing, and
As you
Staff.
recall, he requested to be an add-on at that previous hearing. And after you reviewed, you had some questions in regard to his application, and you wanted him present before making a determination.
Do you guys have copies of his original application?
I can bring it. Is there anything specific you'd like me to start
I think that's the right page that was the questions before. His job was to oversee jobs and make sure jobs were completed
In a timely manner.
in a timely manner. Any
Mis-
board
Mr.
members have questions for Mr. Brock?
Mr. Brock, if you could go ahead and just, because that description's a little vague.
Yeah, I
If
guess
you can
I-
explain some of your jobs that
I
you've
guess I
done?
was the job site inspector. I made sure that everything was done timely manner, quality work, pretty much overseeing the jobs for them.
In the field? Mm-hmm. Did you have much experience as far as the,
In previous years, I actually worked for a framing company for multiple years, as well as a concrete company doing home foundations. So I have pretty much all the experience of all the areas of home building.
did you have experience in the business side?
I actually own a personal business. I've owned it for a couple of years, doing actual home foundations as well as small framing jobs. That's how I got into assisting with the quality control of the jobs.
Have you bidded regular house jobs and full size?
I didn't do any of that type of stuff. I didn't do nothing with the bidding jobs. I just did the overseeing of everything. The behind the scenes stuff was something that's, I knew little bit about, but not like all of that part of it.
What is the desire of the board?
Motion to approve.
I have a motion to approve. Do I have a second?
I'll give a second.
I have a motion and a second. Have any discussion? No discussion. All in favor, raise your right hand. All opposed, raise your right hand. The yeas have it. The yeas have it. You've been approved for the residential contracting test.
Thank y'all.
Thank you, Mr. Brock.
Our next item is probable cause hearing. This is Mark P. Nunes, doing business as Creekwood Builders LLC, state registered license number RR 2828-12147, contractor competency board complaints number 240434 COM. It's in regard to Charles Day, the homeowner complainant at 1202 East Gadsden Street, Pensacola, Florida 32501. Proper notice was sent to the respondent. Mr. Day, are you present today? Mr. Day is not present. And Mr. Nunez, are you present today? And Mr. Nunez is not present. So last time when we were here, this case was continued because neither party was present. It's at the discretion of the board if you would like for me to continue. And Melissa had to step to get her investigation report printout. So as soon as she gets back, we can give an update on whether we've heard from either party recently.
Can we move on to the next and come back to this? Is that sufficient, or
Yes,
here she
yes.
comes, here she comes?
Oh. Melissa, neither party is present for this hearing today. Have you had any recent communications with either party?
The only communication that I've had was with the homeowner, and that was just to verify little discrepancy as we began the last hearing. But I've not heard anything further from Mr. Nunez.
If you'd like, we can go through the investigative report, or,
What's the discretion of the board with this? I mean, it's very frustrating that nobody's here to,
Sorry, Board, I will tell you that the homeowner is in the military, and that's the reason when he didn't show last time I contacted him, he said, I just assumed someone would call me and we'd do it over the phone. I didn't know at the time he was in the military until then.
so it's not a requirement that the complaining party be present.
right?
It is required that the respondent show up.
That's what-
However, he is not here.
That's the frustrating part, you know? What's the desire of the
I should
board?
clarify on that.
Yes, ma'am.
On the notice, it tells the individual that they are required to be present for the hearing, but as far as the rules to proceed, he just has to have been given proper notice. So if we have proof that he was served and he has now failed to appear, then that's on him.
Right.
If he didn't want to show up to defend himself, as long as we have evidence within the record. So I would make sure that we have the return receipt request where it shows a signature for that.
The frustration on our part is that there's nobody here for us to address and ask questions and get details. You know, obviously, Miss Melissa's done her work, but they're saying there's 2 sides, 3 sides to every story, you know?
Right, well, they can introduce the exhibits and you can work off the exhibits.
I would like to see the investigative report, if that's all right with the board. We proceed with that.
I have a copy here. She can pull it up on the screen for us.
And if you are proceeding, I'll get Mr. Day on the phone.
That'd be good if he's available by phone. I think we proceed.
I would like to proceed, yeah. Can you scroll,
Thank you.
can you scroll up for us, Mr. Chambers, so we can start reading? Sorry about that.
Yeah, no worries.
Well, he's not answering, and I text him, and he was aware I would call him. He's in Las Vegas. I know that's where he is. Time difference, but
It's about 7 o'clock in the morning there. He's probably still sleeping from last night. Can you scroll up again for us?
Yes, sir.
So it appears, just in a summation, is that there was a contract started, a deposit given, and a termination, and he's made payment back towards the total of $42,079.69 of $10,000 deposit or payment back. But that's the only payment. That sound correct? So there's still a $32,079.69 balance.
For the record, it would appear that she's got Mr. Day on the phone.
Okay, good. Does he need to be sworn in?
No, it would be ineffective to swear him
Okay.
in at this point.
Okay.
Just make sure he identifies himself for the record, where he lives, and what his connection is to the case.
Okay. Ms. Reber?
Mr. Day, can you hear me?
Yes, hello?
Mr. Day, can you please state your name and address for the record?
Yep, Charles Matthew Day, 9544 Newport Plum Court, Colorado Springs, Colorado.
Thank you. If you can give us a brief rundown of what has happened in this case and why you filed the complaint?
Yeah, sure thing. Sorry, just getting settled in. Let me pull up. I don't have my dates in front of me, but yes, generally speaking, hired Mr. Nunez to start work. There's a lot of back and forth. Eventually, somewhere along the way with permits, things started to stall out. Communication became less and less. Asked Mr. Nunez to refund the deposit we paid him as well as the permit fees. There was some back and forth. Mr. Nunez agreed to pay it. Also along that course, I found out that the permit fee we paid him, he actually didn't pull the permit. And yeah, it's just been back and forth. I reached out to a lawyer as well as the Florida Licensing Board to ask for their recommendations. They said probably would not get the money back. Reached out to my bank to try and get the money back, and then simultaneously, while that happened, also found out I could put a complaint in directly through the city. So we did that, and that's kind of where we are today.
So do we understand there's a balance then of $32,079.69?
I don't have it in front of me, but yes, that's more or less it, minus the deposit for, not the deposit, the payment for the permit. That did get refunded already by the bank.
So they did refund. I know when you and I talked last week, you weren't sure where Mr.
Yeah,
Nunez had stated.
me-
Okay.
Sorry, I'm actually pulling it up right now to see. I haven't had a chance to check. Sorry, it's been a little hectic. Been in the hospital for the past 4 days with a newborn, so a little sleep deprived. I apologize.
And while he's doing that, on your screen is the backup documentation for invoices and proof of payments. So that shows where payments were made to Mr. Nunez.
It doesn't appear that he's disputing that he owes the money. He just hasn't paid it all back yet.
That is correct. In his response, he did not dispute. He discussed that they would agree to make payments. And the last payment was April, that $10,000.
And
I think Mr. Nunez never disputed it. It was just his ability to repay. I've been told by other contractors apparently he owes other subs money as well. So I think everything kind of just unraveled on him at once, and he's not able to pay people. Is kind of where we're at.
and on your screen now is an email response to Melissa from Mr. Nunez. Mr. Day, on 6/4, Melissa received an email from Mr. Nunez saying that you had received a payment of $10,000, but that he was going to be making another $10,000 payment in the following week. Did you ever receive a second $10,000 payment?
No, I just checked the other day at my bank account because I sent him a invoice request via QuickBooks to kind of help him pay it, essentially pay it with a credit card if he wanted to. But yeah, I never saw it. So.
So the balance at this point is 26,858.25.
So in this portion of it, he only includes the deposit, in this email. That was the deposit. He does not include the payment for the permit.
But the permit was reimbursed from the bank now?
That's correct. That's what Mr. Day just testified to. Is that correct, Mr. Day? The bank refunded the permit fee?
Yes, they did.
5221.44.
Mm-hmm.
There's still a balance of 26,858.25 that's left on here, and it was supposed to have been sent in June, and has not been received yet.
That's correct. It sounds from testimony and in the investigative report as if the two parties made a agreement for payments and no additional monies after that initial payment have been received. And so I would like to circle back, one, to do some housekeeping. I'm going to ask that all the documentation attached to the agenda be moved into evidence because we've viewed some of those documents.
Motion to approve?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion's been approved.
And then I would like to draw your attention to possible violations that have been cited by Ms. Reber. The first one being Code Section 1837D8, mismanagement or misconduct causing financial harm to the customer. Code Section 1837D10, abandonment. And Code Section 1837D15B, proceeding on any job without obtaining applicable local building department permits and/or inspections.
I make a motion to move it to disciplinary hearing based on the alleged violations.
I have a motion and a second. For discussion, did he ever actually start work, though, to need the permit?
He did demolition.
Okay, he
And,
did.
yeah, he completely gutted the home.
Okay. Which requires a permit for that, so. Okay. Any other discussion? All in favor, raise your right hand. Opposed, same sign. Seeing none, hearing none, motion's been approved to move to disciplinary hearing. Thank you, Mr. Day, for your time.
Mr. Day, I'll get in touch with you after the meeting. Yes, sir.
Our
Okay.
next item is a disciplinary hearing. The Hallie S. Lovato, doing business as High Point DBR LLC, state registered license number RB 29003574, contractor competency board complaint number 220442 COM. It's in regard to Carl and Carol Moody, the homeowner complainants at 5700 Grand Lagoon Boulevard, Pensacola, Florida 32507. Proper notice was sent to the respondent. Mr. and Miss Moody, it's my understanding, will be joining us via phone, correct, Melissa?
That is correct.
And then we received an email communication from Mr. Lovato, correct?
That's correct.
If you want to go ahead and hand me that email communication. This was just received yesterday evening, correct, Melissa?
Was it this morning
It was actually this morning at 7:37 a.m.
in the meeting?
And I would like to read that into the record. It says, "I guess I didn't read this closely enough and thought it was over, but when I got back in town, I saw the article and realized what happened. Yesterday, I got the letter about a hearing tomorrow regarding the unpermitted work done in our attempt to remedy the damage. I've been out of town and have a long scheduled appointment tomorrow, and it would be nearly impossible to miss it. That said, I acknowledge that we did not permit the repairs and that they should have been. I am a huge supporter of licensure and permits and doing things by the book, so I will make no excuse or defense for my error. Is it possible that I can accept responsibility and whatever actions are necessary in lieu of attending tomorrow? My attorney likely can't make it either, but this was my error and my responsibility. Please advise and thank you for your help. Hallie S. Lovato."
Just a refresher, this is the situation out in Grand Lagoon where we've had some extensive investigating. And it's actually permitted under somebody else's permit originally, number license.
So what we had High Point Construction had a different qualifier.
Right.
At the time, but Mr. Mr. Lovato then became the qualifier. He had a local license and ultimately grandfathered in and now has a state certified license. So in this instance, any action would be taken against whether that local license could ever be reinstated, kind of a thing. Because that local license is inactive at this point. He has a state certified license. So that's what you're looking at here. Any disciplinary action would be taken against that local license. And yes, the county attorney was asking, could you assess fines, things like that? Yes, because this action
Right.
is taken against the local license, you can take any action that is deemed necessary to a local license, so.
So what it would do is just prevent him from being able to reinstate his local license, which he doesn't need because he has the state license.
Do you have the guidelines wrote out here for us, Ms. Jennifer? Yeah, here we go.
I do.
You're
I'm
right
gonna
there.
bring up the administrative complaint.
So we can get an idea of what the perimeters are for the,
Correct. At the probable cause hearing, the board found probable cause to believe that the respondent violated code section 1837 D15C. That provides that a code violation results from the job finished without a permit being pulled, or no permit until caught after job, or late permit during the job, resulting in a missed inspection or inspections. And the board cited that the respondent failed to obtain the required permit to perform corrective repairs to the structure. The penalty guidelines are listed in the next section. For a first violation, a $500 to $1,500 fine.
it also has the ability in the next paragraph there, authority may be limited to obtain a permit or permits without specific, you can read, I'm sorry, I didn't mean to take.
No, you can go ahead.
License revoking for a period of not less than a year or more than 5 years, which his license is inactive, correct? So that's kind of a suspension. And I think we also send our recommendations to the CILB as well, which is the state licensings, so that it will be on his record.
Is this the only violation noted?
Yes, sir, Mr. Bell. This was the only violation noted by the board at the last hearing.
I think the reason for this, because the actual work was done under someone else's license number, Mr. Bell, and it's
No,
a
I'm-
very
I'm-
convoluted case.
Yeah, I'm good to move forward. I was just trying to structure how to do the motion,
Right.
because I want to find him in violation of that code and do the that's what,
So the first thing you have to resolve is whether or not you find a violation.
That's-
So once you make that determination, then you can, then it's proper for us to discuss what the other things are involved. And you would have to determine at this point whether it's a first, well, there's only, I don't think there's a subsequent on this one.
No.
So
This
it's,
first. Yeah.
right.
Right, so if the motion to find him in violation can also include the recommendations at the same time, or do I have to do two separate motions?
I would do it as two separate motions in
Okay.
case you don't get the vote on the violation.
Okay,
Before you make a motion, there is some additional documentation, and then you have the testimony and everything from the probable cause hearing. We need to move all of that testimony and evidence from the probable cause hearing, as well as this documentation that is attached to the agenda today, that needs to be moved into evidence, please.
so moved.
Second?
Second.
Any questions? All in favor to move evidence into record, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion's been approved.
One additional thing I would remind you of is that she did read an email into the record. So you would want to make a determination if you want to have that included as part of the record, as the evidence before you. And she can follow up with adding it, a written copy, even though she read it in. She can follow up with adding a written copy to your documents.
I have a motion to include today's email into the record.
So moved.
Second?
Second.
All in favor, raise your right hand.
This is Carl
All
Moody.
opposed, same sign. Seeing none, hearing none, motion's approved.
Hold on, you're on speaker and you're talking.
Yes.
And we also have Mr. Moody present in case the board has any questions.
Okay, so the first thing we need to do is see about the violation.
I'll make a motion, he's, to find him in violation of the Escambia Code 87-37, paren D, paren 15C.
Second.
I think that, that's not the right one.
That's what I was reading.
I know she scrolled it up, but I think I have here 15A.
That's correct. It was, on the investigation report, it was not cited correctly. We did have it correct in the
It
hearing.
is C then?
It is C.
Okay, just making sure. Okay. And have a second?
I second it.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion approved. Sorry, I got stuck reading the A's and the C's. So, does anybody have a question for Mr. Munez? Not Munez, Mr. Moody, excuse me.
Mr. Moody is available for any questions.
Yes, I was hoping that you guys would have had a chance to read the submission that I made that sort of recaps the whole process and clearly potential 489 violations by High Point early in this permitting process, which goes beyond failing to ask for a permit for the remediation work. And it's all documented in the memo, but I'm happy to recap it for you guys if you would like me to.
The 489, Ms. Christie, the Florida Construction Law, Chapter 489, that he's referring to, we deal with local county ordinances, correct?
What section of
I'm
489?
sorry, I am having a little trouble hearing you, but by definition, Escambia County and any other local county or city that decides to do their own licensing oversight adopts 489 by definition.
Yes, sir, we're fully aware of that, but our disciplinary proceedings is based on local ordinances.
Well, this is a
Correct.
permitting question.
That's,
So it's going to be related, it's the county that does the permitting.
that's
So
what
it's
I'm
going to
trying
be
refer
related to our
yeah.
code on permitting.
So it's relating to the county. The construction, chapter 49 is the construction law in its entirety, but this is a permitting of a local jurisdiction. Is that correct, Mr. Tim?
Well,
Mr. Moody, if you can hang on just a moment.
permitting is,
Mr. Moody, if you could hang on just a moment, please.
okay.
Mr. Chairman,
Yes, sir.
the construction, the Florida Building Code, for example, is governed by Florida Statute 553. 489 is contractor licensing. So we do have two different things there. The permitting and inspections will be governed by 553 and the Florida Building Code.
Right. The 489 is the construction law side. Is that correct?
Yes, that's the contractor's
Contract law side.
licensing.
Right, right.
Yeah.
So that doesn't apply to the permitting process.
In relation to a contractor, if whatever they're trying to permit, for example, if it's within their scope, of course. But the actual permitting and inspection process is 553.
553, right, the building code. Just want to make sure Mr. Moody was clarified with that this, it's a technical thing, I guess, but in reality, the 489 is to do with the licensings, but the actual application is through the building code 553.
Yeah, that's correct. And for example, a contractor, based on their, whatever license they have out of 489, may not qualify for pulling a permit that is covered in 553. For example, Mr. Robinson, I'm assuming, wants to pull a permit that he cannot. That's why he's wanting to take the general contractor's exam.
Right.
Yes,
And-
yes, and one of the points that I actually raised goes back to the pulling of the original permit, not the permit to do the remediation project, but Mr. Lovato was unlicensed at the time that permit was pulled. His company was qualified by another individual, Tyler Weldon, and the 489 statutes say if you are not qualified, then you pull a permit, you have to have the person who qualified the company or somebody licensed involved in the construction of the residence. And we have an affidavit from Mr. Weldon, which we submitted, who says he had no knowledge the permit was pulled in his name, and he had no involvement with the construction process. And that goes back to the time when the permit was actually pulled. Now, Mr. Lovato was licensed personally shortly thereafter, like a week after they pulled that permit. Then he registered High Point again with his license number, which is appropriate. But on that application, he showed Mr. Weldon as a financially responsible officer. And once again, Mr. Weldon was unaware he was listed on that application as a financially responsible officer. But the point is that after that registration happened, Mr. Lovato was the only licensed contractor to do any work on our structure throughout the whole process. So there are clear ties of High Point and Lovato to either 489 violations on pulling that permit, or afterwards, when he did pull the permit, being the only licensed contractor working on the construction, he's clearly tied to the construction under his license. And I believe I've made some citations in there that say changes in licensing categorizations don't really matter. You are looking at what the violations were when they occurred. And I also believe that you guys have the authority to investigate these particular issues.
Mr. Moody, they were investigated. Ms. Reber does a very good job with that. And the qualifying agent is the proper terminology that is used for the original permit being pulled in, the gentleman, I don't even remember his name, that pulled the original permit. So that is the man that is responsible, according to Chapter 489. He is responsible for the project, for the financial, I mean, he's got a lot of responsibility. Whether or not he knew it, that's probably gonna be a civil case. We have a county attorney that can address that
He didn't even know
better.
the permit was pulled.
I do think that was more of a civil than, because principally, there was a permit pulled by a qualifying agent, and work was done under that permit and under that license. And that's all we can look at from our perspective. Now, if it was done wrong beyond that, I think there's a big civil thing. Again, our county attorney can kind of address more, is that in those lines versus what we deal with here is the competency board. Ms. Christie,
Well,
could
it's
you?
interesting that
Mr.
Excuse-
Moody,
excuse
I'm gonna
me.
ask you to
One
please,
party against
Mr. Moody?
Excuse
Mr.
me,
Moody?
Mr. Moody, we're talking here.
Can,
Mr. Moody, you're talking over other people. Can you just hold on a minute, please?
We have a court,
Yeah, I'm sorry, I have trouble hearing.
we have a court reporter that we're driving crazy trying to figure out who's talking and saying what. Ms. Christie?
as far as a civil case, I can't give him advice on that.
Right, right.
Because I'm a county attorney. So he would have to seek the counsel of a civil attorney.
Right.
You are aware he's been through that process.
Correct. I have been through that, and the civil suit was settled via mediation, but it was settled strictly for civil purposes, and it was made very clear to Mr. Lovato and High Point that given the amount we settled for, that I was not going to drop the builder complaints.
Thank you, Mr. Moody. Thank you for your input here. I think we're pretty much locked in to all we can do, though, is look at this violation of proceeding without the applicable building permits. And I totally understand what you're saying. And as an individual, I don't know if I'm even allowed to say this, but I am sympathetic as an individual. I hope I didn't get in trouble. But at the same time, we have perimeters we have to work with, and this is all we can work in here. We can be very individually sympathetic to what you're dealing with, but here's our scope, and this is pretty much where we're at.
Well, then I would ask your administrative people to send me an email specifically stating why you believe your scope is so limited. As I said, the person that qualified the company didn't even know the permit was pulled.
Mr. Moody,
Had
I just
no
explained
involvement
that.
whatsoever, and so that kind of goes to the ethics of the person that pulled the permit in the first place without informing the person that they had pulled the permit, and that goes to the people that are working in your county.
Mr. Moody,
So,
Mr. Moody,
I would ask you guys just to send me that, and then
Mr.
I'll
Moody.
decide what my next steps are.
Mr. Moody, can you hear me?
Yes.
Okay, we're gonna proceed forward, but I want to tell you again, this gentleman that had been a qualifying agent for that business, had been a qualifying agent for a considerable period of time. This is nothing new to him that he was getting permits pulled under his license, and the county cannot question every time that it comes in. If he's the qualifying agent for that business, the county and the chief building inspectors here, these guys, if it's in the paperwork for that man to be the qualifying agent and there's a permit requested, they are obligated to issue that permit. And they did not do anything wrong. They done the job that they're supposed to do based on paperwork being properly filled. Unfortunately, we are very limited with this to just this one item. And we're going to move forward with this one item, just letting you know, okay? Thank you, Mr. Moody.
Yeah.
Thank you for your time.
Once again, I would like.
Thank you for your time. do I have any kind of I don't mean to be rude to Mr. Moody, but we got to keep moving here. So everybody sees what we have for the violation, and it's been, if I can recap, we have motion and seconded and approved that it is in violation. Now we need to look at the fines, discipline, what we need to do, and what we need to send to the Construction Industry Licensing Board.
I would like to make a motion since it's a first violation, the fine of $500 and no further action from that.
Do I have a second?
I second.
Okay, I have a motion and a second. I mean, discussion. Okay, all in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. Motion is approved for $500 first violation with no further on the license, which is ineffective anyway. Now, we do have something to send to the CILB, Construction Industry License Board. What would we like to go now? He is state certified, so this will bring to their attention what has taken place here locally, which is a good part of the process, because then the state gets to know what we're doing down here and not be a disconnect. So what is it that would be the board's desire to send to the Construction Industry License Board?
Can we just, for informational purposes only?
We can send just what we've decided today and documentation forward, yes, sir.
Okay, I'll recommend we forward this to the state.
Second.
Okay, any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none. We're moving everything today, including decision, to the CILB.
I just want to make clear on the record that what you're doing is just sending it for information purposes only, and you're not
Right.
asking them to take any action.
Right, no further action.
So if you can include that in a second motion,
Okay.
which would say no further action, so it's clear for the record.
Yeah, yes, no further action is recommended for them to take on
Can I
this
have a
item.
second?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hear none, motion is approved. Thank you, Ms. Christie, for keeping us straight.
Oh, don't give
Okay.
me that much credit.
Well, you try. Okay, next case.
Our next item is Christopher W. Brown, doing business as Shooting Stars Construction LLC, state registered license number RG 0019314, contractor competency board complaint number 230557 COM. It's in regard to Vin Cal, the homeowner complainant at 3709 Idlewood Drive, Pensacola, Florida 32505. As you can recall, there was a final order issued in this hearing, and so this has been queued for disciplinary hearing for non-compliance with that final order. Mr. Brown did come before the board at last month's hearing and requested a reduction in restitution. That there was a reduction in restitution that was ordered, and that is detailed within his notice of non-compliance. Subsequent to that, Mr. Brown provided some documentation requesting for a payment plan from Mr. Cal. It was a letter to Mr. Cal and to the board talking about a monthly payment plan. I believe that Mr. Brown is present today. I do not see Mr. Cal. Oh, yes, Mr. Cal is also present today. At this time, I'm going to have both parties stand and be sworn in. So I'm going to bring up the notice of noncompliance. For Mr. Brown. And you will see it come up on your screen, and it details that the board assessed a final order in the complaint, and that the restitution assessed was reduced to $188,251.18. To date, that restitution, there have been no payments made toward that restitution, and both parties are present to discuss.
I think there's a letter also that Mr. Brown has sent. I don't know if the board would like to see that. Yes. Thank you for bringing that up for us.
And I would like to say that the fines that were assessed to Mr. Brown in that final order have been paid. This is only in regard to restitution.
Restitution. Mhm.
Yes.
You can go back to the other one. I just wanted to make sure everybody was aware of this. Thank you. So the ask today is,
The ask today, the request today from Mr. Brown is $1,000 a month in a payment plan. I would think that you would need to hear from both parties in regard to the ask. At this moment, we had a final order that was issued. He had a time frame in which to pay the
Right.
restitution. The restitution was reduced, but the restitution is unpaid.
does the board want to hear from,
Yes.
okay? I'd like to hear from both parties, please.
And also I would like for all of the backup attached to the agenda to be moved into evidence, please and
Do I
thank
have a
you.
motion for that?
So moved?
Second.
All right. All in favor, raise your right hand. All opposed, same sign. Majority is approved. Motion has been approved. So we're ready to hear from the parties so we can move forward.
Mr. Cowell first or Mr. Brown?
Whichever you want to do.
Mr. Cowell, if you want to come.
Good morning. My name is Vin Cao. I live at 1743 Cedar Lane in Pensacola, 32514. Yes, and I just want to say thank you for the long process, and we are hurting, but it's over now, so thank you. And I would like to ask is, clearly, Mr. Brown never take any action, even final order or whatever you ask, anything that we listed and anything. So just want to bring in front of you that today he asked for $1,000 out of $180,000. How long do you think that will last? And what is collateral if he doesn't pay? I just want to know, because in front of you he said that. Clearly he didn't do anything. And then in the letter he threatened he'd go to sue the board and us. I didn't do anything wrong. We asked him for help. Whatever we proved, we have to prove, we did. And clearly that he didn't do anything now. He just tried to get out of it without paying it. I just want to say it out. And all I want initially, I will accept any payment, but what happens if he doesn't pay? Any collateral? And it's something that on writing, and we will take to civil lawsuit, law court, that we will get it done. Not from the board, but upon the other part. So that's what I'm asking. And then also initially for the last 8 months, he didn't pay anything. So he took me $30,000 in cash. In the letter, we prove it. I want it back immediately, and then we can talk about payment. Thank you.
And Mr. Cal, at the last hearing, you were in agreement for a reduction in the restitution amount?
Yes, I do. I don't have a problem with that. Yes.
Yes, sir.
Can we give us the new amount, 180 something?
That number was $188,251.18.
Thank you, Mr. Cal.
Mr. Brown?
Chris Brown, 1234 Brown Circle, Gulf Breeze, Florida.
Pedro Perez, 4912 Suffolk Road, Pensacola, Florida. We have not been able to verify if any of the action has been taken on that house. And we are agreeing on paying this amount of money, and we don't even know if the money have been used for any of the situation that he's talking about. We have not been able to go back since the day they decide to close the door and fire us until today. So we are in a blind situation right here, and we are not agreeing with you guys and with him to pay an amount of money that we don't even know if it was spent inside the house. This is a real situation which we still gonna fight for the justice of it, because we believe we don't owe that kind of money. It has never been, I don't think, in the county history has ever been punished that big, $180,000. But we still have to agree in any situation that you guys have put us into it or ourselves into it, and see if we can go ahead and start slowly and $1,000 a month, and every time we have finished a house and get it more business, so we increase the amount of it. But right now, this is all we can do in order to keep the business going. If it is approved, we will really appreciate it.
Mr. Brown, do you have any comments?
No, he did all the talking for me.
Thank you, sir.
When the board made the decision for the restitution, we didn't pull something out of the air. This was real numbers that was submitted of work that was not done. So I just want to clarify, and the beauty of this wonderful country we live in is that we don't have to always agree. There's a court system, and that's a right that we all have, and that's a good thing. But I just want to make sure you understand that we didn't just grab something out of the air. These guys up here are very cautious and conscientious about what we do here.
Yeah, but
And
my question is that we have never been approved to make sure that this amount of money that we are paying has been put back in the house. That way they say they destroyed everything that we did, which is the first time ever. We just finished a house this week, and we have the CO on it. And you can go ahead and go look at it. We don't do such a cheaty job that they believe that we are not qualified for it. But we would have never the chance to finish the house because they were not in agreement with anything that they picked up and that we did. So, but the only thing I would ask is, okay, timing, but besides that, we won't even know that they put that money back. Probably that money go back to his pocket, not to the house, like we believe that he's doing it. So, we under the blind here. You under the blind, and I under the blind. Nobody have go there and find out if all the tiles are picked up and thrown away, if all the cabinets that we pay for it, we still paying for it, it's still there or not, they've used it or not. We don't know. We don't know anything because they own the house. We're not allowed to go back. You're not allowed to go back unless you ask for a court order. So I'm paying for something that I don't even know. It's just like paying a child that I don't know. I've never been with it.
And only thing we had was the evidence that was submitted with photos, et cetera. So again, we didn't just blindly make a decision
Correctly.
off of just some word. We actually had evidence of
Yeah,
what
but
was
with
there.
the
So,
evidence, they already changed all that.
well,
Did the
and that's,
county have the evidence that we already changed everything? No, you have not go back there, she have not go back there, nobody have go back there and find out if they are lying or not. They could be a liar too. Like he says that we are liars, he could be a big liar too with a nice face. So that's the difference. We allowed to go back, and see if they change everything. I got pictures. Then I find out, they put new windows, they put new doors, they put new tile, they put new bathrooms. If all that is done, then the money is satisfied for him, not for me. Because we done a good job, for many years, 30 years of business, doing a good job.
I understand. Well, just, again, all we can go by is the evidence that was submitted to us, and what was done was not right, and that's where we,
Can we
done
go
for the
back and
restitution
check?
to make it right, and that's up to him what he does from that. So
Can we go back and check?
I don't have a way of doing that. All we again have is the evidence that was not done right the first time. Whether or not he does it right, or if he burns his house down or throws it away, that's nothing to do with us. We just,
All right.
we're following the
That's what I
guidelines of
said.
what was put up was not done right.
We going in the blind here. We are paying,
Well, we're not really going the blind. Mr. Perez, again, what was contracted to do was not done properly, and the board decided that restitution would be paid because it was not done properly. Is that correct, guys? I'm not trying to put words in anybody's mouth. And so that's what was done. And whether or not the owner chooses to put cardboard boxes up or real cabinets or whatever, that's his decision. Our thing was, the contract said one thing, it was not done, and so the restitution is offered in the same manner. Is that, I'm not trying to get anybody to agree, I'm asking for input.
Mr. Chair, maybe legal can help staff, but shouldn't this be before an appeal, not back in front of the board?
He missed his window for appeal.
Okay,
He had 30 days from the day that the final order was entered.
all right, thank you.
My law is 30.
Thank you, Ms. Rainey.
And just to be clear, he had 20 to go before the Board of County Commissioners. He had 30 to go before Circuit Court. And so he didn't meet either of those deadlines.
So they're asking for $1,000 a month, which is 15 and 2/3 years.
Mr. Chair, can I make a comment?
Yes, sir, please.
I don't see how we can adjust our decision like that at this point. All the appeals process were skipped. You know, we're back here on where we started, and I can't agree to it as a member. Thank you.
Thank you for your input. Anybody else have?
Is that a motion?
Is that a motion?
The matter that's before you today is that he received a notice that he had failed to comply with the requirements of the restitution agreement. So that's the matter that you have to make your decisions on. Based on that, then you have, if you find that he has failed to meet that date, that deadline of making any payments or paying that money, then you would make the decision of what are your options in relation to that when you failed to meet the requirements of the final order of the board.
the only thing
So it's also a two-step process.
The only thing we ask, yeah.
Excuse us for just a minute. Let's,
Excuse, if we go that direction, should our findings be written into the record prior to this, or should it be just established today? The consequences, you know.
It would be the same as any other hearing. So we do it as you hear it today.
Thank you.
So I guess what we're asking, it was not made if the decision, if he didn't make the restitution, what the actions would be in the prior meeting.
Well, part of what you need to know, so what you can do, you can determine that he hasn't made the restitution or not. You could say that he has made the restitution if there's any evidence before you that presents that. So then your second step in that would be to determine what is the penalty or what is the what should be the result of having not paid it. One of the things you'll want to consider in the second step is whether or not he had the ability to pay. That evidence hasn't been presented to you yet because you haven't made a decision whether or not he paid or didn't pay. So your first step is determine whether or not he made the payments. The second step is determine whether or not he had the ability to pay.
Okay, so, Madam Secretary, do we have any evidence that any payments have been made?
We do not.
Okay, so I need a motion to determine the obvious, that no payment has been made. Is that right, Ms. Christie?
Right, that would be the first step.
Okay. I need a motion to determine that no restitution has been made.
Motion to confirm that no restitution has been paid to date.
Second.
Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is unanimously approved. Now, based on that, based on the fact that there is nothing paid as of today, what is the board's decision to do action because it has not been paid?
So based on that, you would want to determine whether or not he had the ability to pay. There is evidence that has not been taken on ability to pay, and that's certainly something you can ask of your county employees who would know whether or not he's been permitted or had any other jobs in the 8 months since your rendition of your original order. So they may want to be heard on that. He may want to be heard on that. So those are things that you would take into consideration before you determine whether or not or how you want to proceed as far as punishment or resolution of the fact that he hasn't made the payments. If he had the ability to make the payments, those types of things would weigh on what your longer determination. And I think that brings you back to what you originally could have done, which is suspend permitting privileges, suspend the license. Those all come back into play.
It's any disciplinary action within our county ordinance in regard to disciplinary action. So you have a multitude of actions you could take.
Mr. Perez mentioned that they had finished a house just recently as well. Do we know on our record any COs issued from our county? I know you could look at Santa Rosa as well.
So staff would like to present as evidence. I have our software, My Government Online software. This is the licensing card for Shooting Stars Construction, Mr. Brown. You can see within the associated permits, there are quite a few permits that have been issued since that final order was issued back in November of 2023. Looks to be that there have been 7 building permits, which means 7 projects, because I see land use approvals for each of those. So without going into each one, I mean, I can if you would like to see those, but it appears that at least 7 additional projects have been permitted since the time of that final order.
So there has been work
Not yet.
moving
And
forward.
we do, on those 7 projects that have been permitted, there have not been any COs issued. I know that
This one. We
I know
still
that we've
working
been
on
in communication here recently about some COs for these projects, and so, yeah. I know that a few are close, very close.
Yeah. We are working on trying to put up the money some kind of way. We don't have the ability to come up with $108,000. So we want to have good faith of starting with $1,000 a month. And every time we have closed a house, we come out with some 3, 4, 5,000, whatever percentage we have made profit. We would like to put it back on a trust account with their name and our name to make sure that the county have an ability to find out that we pay every month.
We want the money going to an escrow account.
I don't know if we have the ability to do that.
You can't order that. That's a decision he can make if he wanted to. All you can do is enforce your restitution order.
Right.
However he decides to do it, he can do that.
And we don't have that ability to make that decision?
Well, it can be done through the owner. If he agrees on a trust account, with both names on it, and we would like to know how much money we pay and if it's being used for the restitution side.
If they reach an agreement beyond this board, that's different. I don't know if they have a civil case pending, but all you can do is take action on the restitution
That's all
amount
we
that's
can
due.
do is, yeah.
Yeah, we will have a civil court as soon as we have this situated.
I can't.
Yeah, I know.
So what I was bringing up on your screen is the permitting records that I was talking about. It looks like there are quite a few new single-family dwellings in the works, the most recent being permitted on June 28th, and it was released and issued on July 2nd. There's a duplex, there's another new single-family, a third new single-family. That's the duplex.
Yeah, we are trying to get a small.
And then another new single-family. So you have several projects.
Yeah, we're trying to get some small projects so we can go ahead and finish it and do it in 2-3 months project time and collect a little profit on it so we can go ahead and have the ability to start paying more money than $1,000 a month.
So
What's the-
just to clarify, this documentation is public record, the permits, that's all.
Right,
I just want the board to take notice that it is all public record, it's viewable to
Right.
all parties.
So what is the discretion of the board?
And also, I'd like it to be considered as evidence for this hearing.
Okay. We have a motion?
Motion to move this into evidence?
Do I have a second?
Second.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved. What is the decision of the board on the restitution?
Without some concurrence from the affected party, I don't see anything we can do to make it, the payment plan set up. That would have to be between them, in my opinion. So I appreciate any other opinions of the board.
You may want to see if the party wants to be heard on the matter.
Mr. Cowell?
Mr. Cow, you may want to see if Mr. Cow wants to be heard on the matter.
They had 180 days from when this was,
That's correct. So they had 180 days from the date of the final order, which was back in November.
so we're past.
We are past that time
Right,
period.
that's what I'm making a point of to the board, that we're actually past the date of, and no payment has been made at all. Just make sure everybody's on the same page.
Would the board like to know those other projects, what those contract values were, or anything like that?
I don't think so, not at this time. I don't. But I'd like to hear from Mr. Chow.
Yes. Good morning again. Like I said earlier, 180 days plus 2 months, 60 days from the last final order. And all the promise on the talk, but didn't do anything. So imagine when I get out of here without a board, what do you think? It won't be nothing happening. So like I said, $1,000 a month, $488,000, like what, 15 years, like you said, plus 2.5, yeah. I need the collateral. I need something to prove it. And we don't need a trust. I need to send a check in, and then we record that, and that's it. And that's all I need. And then if you say $1,000 a month for the last 8 months, I need that money right away to prove it. Whatever he say, he does, to be honest. Thank you.
Thank you, Mr. Cowell.
May I ask council a question?
Yes, ma'am.
At this point, really, what can we do?
We're pulling that up for you.
Thank you.
While she's reviewing that, you would want to make the determination based on the evidence before you whether or not he had sufficient ability to pay. That's why she was asking the question about whether or not you want to know the amounts of the other projects.
So I just need a motion whether or not he had the ability to pay.
Right, you would make the determination whether or not, you would want to make a finding whether or not he had the ability to pay, because of course you don't want to nail somebody when they didn't have the ability to pay. That wouldn't be appropriate.
And these other guys can ask, but I'm kind of, so do we have the ability to ask them to provide us financial statements? I mean, Mr. Brown, Mr. Perez, they could be sitting on $5 million apiece, and I'm just making a fictitious thing, and this could be a drop in the bucket. I mean, what?
Well, that's why Jennifer was showing you the other contracts, the other money that's still coming into the company to show you whether or not his company is viable and able to make those payments.
Well, I understand in the future of it, but, I mean, he may have $1 million sitting in a banking account. I mean, it's kind of a broad thing for us to say, he could have already paid this if he had a bunch of cash. How do we?
Well, the point is, there's nothing been paid. There's no activity between the time that it was done. There's no appeal. There's
Bottom
no
line.
activity.
But-
And, there's been no, here's my payment plan that makes reason. It's still trying to go back and argue
So the only
original
thing,
approval.
connector I can find is that we're seeing that there's permits and amounts of money that has come in the last 6 months so that they could have made a payment
agree.
in here because there was work coming in. That's the only thing I can see with the tie-in, but again, that's kind of a vague. So the tie-in, Ms. Christie, is that there has been work coming through their company in the last 6 months, and something could have been paid because they have contracts coming in.
And have you
we
s-
can see that with the evidence, yes, ma'am.
And have you seen anything contrary to the fact that they did have the ability to pay? Because if he had presented any evidence contrary to that, then that would be evidence you could consider. Have you received evidence contrary to the fact that he had the ability to pay?
We have not.
If we suspend his license or revoke it, they're not gonna get anything, so it's not gonna help Mr. KO at all. So I don't know, we're limited. It needs to go to Silver Court and let them fight it out and put a payment plan on it. I'm not sure exactly how we do that. But I do want Mr. KO to know that if we suspend his license, you'll probably get nothing. So, unless you go to court. So, I mean, I'm agreement with a payment plan, but I don't know if we've never done that, and I've been here forever, and we've never done a payment plan. So it's something they work out together,
So let me assist you a little bit. So you're making a determination that he has the ability to pay at this point. Is that the determination the board, is that the motion
Do I
or
hear
that
a
he doesn't?
motion that he has the ability to pay something towards this? Is that what you're asking for?
Right, you're basing on the evidence that's before you whether or not he has the ability
Based
to
on
pay.
the evidence before us of the number of permits and the number of work that he's had, do I have a motion that he has had the ability to pay something towards this?
So moved.
I have a second.
Second.
Any other discussion? Please no. All in favor, raise your right hand. All opposed, same sign. Hearing none, seeing none. The motion has been approved that there was evidence that something could have been paid in this last 6 months.
Now that you have that motion resolved, the question becomes whether or not, so what are the punishments or what is the board's abilities to enforce their restitution order? That's what you're looking at. This is your restitution order and the enforcement is incumbent upon you to make it happen. There are options beyond suspending suspending a license, you can suspend permitting privileges as opposed to suspending license. That would allow him to finish the projects that he already has in place. Is that correct, Mr. Tolbert? Sorry. I should ask you, sorry.
My apologies, I was working. I didn't hear a thing.
I'm
I heard
sorry.
Talbert.
I was talking to him about the ability, what they have in front of them as options to enforce their order. And one of those can be that they can suspend permitting privileges without affecting the permits that he already has in place.
That's correct.
So that would mean he couldn't pull any more permits. You wouldn't be suspending his license. He just couldn't pull a permit. You could also put his permitting privileges under probation.
That's-
So there's several options, and you'd have to ask the building officials more detail on that.
And-
Probation, reprimand, there's several options. Is that right, Ms. Talbot?
That's correct.
How would the probation work, just for clarification for the,
Well, I've seen it work in the past is, you know, he would report, I guess, whatever meetings you would like for him to attend. And then we would do a record search for, you know, any violations, and we would report those violations on any permits he had, which not a violation if it's fixed. But just give an update to the board on how the contractor's progressing.
So maybe you could help the board. They're trying to figure out a way to enforce their order and still allow the projects that exist at this time to continue, is the way that I understood the question. Can you give them any information on, would that be the suspension of the permitting privileges?
Well, further permitting. Your goal is to have the contractor finish what he's got going so far, right?
the goal is to get the full restitution, and I don't know if these are enough jobs to finish it, and if not, then he'll need even more permits.
My advice on that would to be make that decision a little later on. If you need to give him the opportunity to pull more permits to make the restitution, that would be my advice, to see how he's doing in a certain period of time.
Okay.
Mr. Chair?
Yes, sir.
Word? We've heard testimony here today that he didn't agree with the final order or the revised final order or the amount, and that's what I understood. That is way different than trying to adjust the schedule and the non-compliance with the final order that's 6 months old. It seems late to me. That's all I want to say.
We need to act upon what is actually in front of us.
I think our hands are tied.
That's exactly right.
So that's accurate. Your decision today is based on the fact that he has made no.
Zero payments.
Zero payments, there's, no restitution has been paid. Your final order stated that if restitution was failed to be paid, he would be brought before the board for further disciplinary action. Even if you take disciplinary action, there's no guarantee that Mr. Cowell will ever be paid any form of restitution from Mr. Brown. Your discipline is for his failure to not comply with the final order that you set forth.
So the suspension of further permitting would allow him to finish what he's working on now?
Well, that's up to the board.
No, I mean, if I make the motion to suspend further permitting.
With, and you
With
may
a
add to
timeframe?
that he's allowed to finish the projects he has permits on now.
And a suggestion from staff would be, for frame purposes,
That's-
suspension of permitting until the restitution is paid.
Okay, I'll make the motion to suspend permitting until the payment is made for restitution.
Do we want the full amount before we start him back up, or do we want to?
Well, let's go, that'll be my motion if we can
Sure.
get a second, we go to discussion.
Second.
Okay,
Okay.
For
So
discussion.
I have a motion and a second.
Okay.
For full restitution to be paid before any further permits are allowed for Mr. Brown. Okay.
Correct.
Make sure we're, discussion.
So what his actions are during this period of time. and
Mr.
what
Brown, if
agreements
you
he
could
can
have a
make
seat. They're in a
with,
discussion phase. Thank you.
Mr. Chow, would be whenever we could reconsider that permitting, lifting that suspension. But he needs to make some type of agreement or some type of restitution for a period of time to
Particularly
Mr.
within the
Chow.
next 2 or 3 months, not next year. but-
Well, they would have to come back and say, hey, we have this agreement, or we have.
Um,
Fine.
It wouldn't necessarily have to come back before the board, as long as we can confirm that restitution payment has been made, we could automatically reinstate permitting privileges.
But that would be for full restitution. But if he's making a payment plan or something, agreement has been made with Mr. Chow, would we have him come back before us in that?
I would think that
Circumstance.
Mr. Brown would need to request that
Correct.
of the
Right.
board once that's been accomplished.
Correct. But we're just not seeing any evidence of any effort to make the payment that we can move on. So
So it appears like, let's just use 3 months. If in the next 3 months, they're substantially paid to that, and Mr. Brown came back and said, can I get my permit and privileges reinstated because I've paid X dollars, then we could reevaluate that and say,
or some agreement with Mr. Chow of how that's to be made.
Yeah,
I
yeah.
agree. So, but for right now, until something.
until
is-
something's done, this kind of puts the foot down until something's done. Is that okay? Any discussion over here? Anybody? Anybody else?
I'd like to say something first.
Okay.
I have a motion on the floor, and I can't interrupt that with rules, Roberts. I don't think I can until we get through.
If you had additional evidence, information that would help you to make,
Do you have any additional evidence that will help us with this? Yeah. You have to walk to the mic. I'm sorry, Mr. Brown, you have to.
Each time I pull a permit, I can pay like $2,500 every time I pull a permit towards his fees.
Okay.
That's what I was gonna tell you.
What we're saying today, Mr. Brown, is.
That's the only way I can come
Mr.
up with
Brown,
money.
Mr. Brown, let me talk to you for just a second. This board's pretty upset for the fact that 6 months, you ain't done nothing. I'm talking. Okay? 6 months. You haven't even paid $500. And so the board is to the point of saying, we're suspending your permit and privileges until you start showing your action yourself. I know I'm being a little firm, but I'm telling you, we've been lenient, and now we coming up asking for a payment plan. You haven't even done anything. So the board is saying, until you start showing good faith, and if you come in and you pay X amount of dollars next week, and you come back before the board, or however, we arrange this thing, your privileges can be removed, and you can get permitting again. But we've got to see some action from you before anything will be allowed from here. Am I saying this correctly, board? I don't want to just speak up for everybody, but I feel like I'm feeling the consensus of what's here today is that you haven't showed anything to us in good faith. Nothing. Zero.
Well, I've been waiting for when we sent him the letter, we've been waiting a response for him, find out if he's gonna accept it or not.
That has nothing to do with what we did.
I know that, but I understand what we were trying to do
if I could,
on it.
just so that everyone's clear, what's before the board, the motion that is before the board is suspension until the payment of the restitution is made. So that's what's before the board. So any other considerations are not part of this discussion right now.
He would have to come back based on, if he did make a substantial payment and request for that to be reinstated.
That's not a part of your motion at this time.
That's not today. I'm just letting him know for the future, though, that he could do that. But as of right now, nothing's been done, so we're making this statement.
I'm just trying to keep the record clear for the
Thank you.
board as they make the consideration before the vote.
Thank you, Ms. Christie.
So if I can't pull permits, how am I gonna pay?
I have us move that we close this discussion down. and let's move forward. We've got other items to discuss.
Okay.
Agreed.
All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is unanimously approved.
For the record, the motion
To
to
suspend the
close the
license.
discussion didn't need to be made, it was just a recommendation. And the motion that you just voted on was the motion to suspend until
Yes.
the.
That is
um,
correct.
Yes,
Until,
to suspend the license until restitution's been paid.
all right. Thank you.
License permitting privileges. Okay, thank you. Next case?
Hang on, let me clean up my screen. What, Kristen? Our next item is James B. Freeman, doing business as Freeman Roofing, state registered license number RC 0058058, contractor competency board complaint numbers 23112, 123 COM, and 2300670 COM. It's in regard to Nick and Chloe Sexton, the homeowner complainants, well, the property owner and complainants at 101 South F Street, Pensacola, Florida, 32502. This is within the city limits. Mr. and Ms. Sexton, I see are present, and then we also have Mr. Alexander, representation from Mr. Freeman present. Again, this is also a failure to comply with final order for this hearing. It's notice of noncompliance. Mr. Freeman put in a request for a continuance for this hearing, and that was to the chairman, and the chairman said that he could bring his request to this board. I'm sure that's what Mr. Alexander intends to do today, so I don't know if you want to hear from Mr. Alexander first or continue on.
We can hear from Mr. Alexander.
Good morning, Board. Ben Alexander, 811 North Spring Street, Pensacola, Florida, 32501. I'm counsel for Freeman Roofing and James Freeman. Very quickly, I spoke with Ms. Reber earlier. I didn't get a direct copy of the notice of this hearing, so I was advised by my client a couple days ago, I guess after they'd sent in a request for the continuance. So the legal position I take is slightly different. And so as the board is aware, you entered a final order, I believe, back in April. We timely filed a notice of appeal that went through the Board of County Commissioners that was subsequently denied on May 20th, and an order was rendered. Subsequently, pursuant to the applicable rules of appellate procedure, we filed a petition for writ of certiorari. And this is a particular type of appellate procedure seeking an extraordinary remedy. And basically, it's an appellate procedure when we're dealing with something that's not a court. So, for example, quasi-judicial boards, those kinds of things. So under the competency board's rules, there is an automatic stay that's entered when an appeal is filed. I believe this under the rules referenced the appeal to the Board of County Commissioners. However, again, what we have done is seek a subsequent appeal of that decision, and we filed a petition for writ. Like I said, it was timely. It was filed on June 19th with the Circuit Court. I provided paper copies today because, again, I wasn't provided notice of this until a couple days ago, so I brought paper copies of the writ today. Our position is that as we are still in the process of reviewing the board's decision, we would request that the stay by the rules be continued until such time as that review be completed. Among other things, it would maintain status quo for the duration of the review. Certainly, what we don't want to have is a situation where if a court were to reverse anything, we'd have to go back and undo anything subsequently. And so I'm not so much asking the court to continue, or I'm sorry, the board to continue it. I would just ask that the board not take action at this time pending further review and in accordance of the board's own rules of a stay pending appeal. I do believe that the petition does constitute appeal. It was filed under the rules of appellate procedure. And so the stay should be extended for that duration until the review is finished, just so that we don't have any issues where later any kind of reversals might be had.
Miss Legal.
I just received a copy of it. We haven't been served yet until we're served on it. We don't even know if a court is going to accept it at this point. They can certainly always even deny that they have jurisdiction because of the window of time that's allowed. It's from the rendition of the final order, so I need to look into that matter. The final order in this case was rendered in April, even April, right? I don't want to confuse it with the last case. So I need to look into that. There are legal matters that I need to look at. I think at this point, the defendant has asked for a 30-day, I think he asked for one, not you, not you, but Freeman Roofing asked for an extension from this because he's out of town and unavailable. I think it's reasonable that he's not available. I think he only received notice of the hearing 2 weeks ago.
He received it on the 26th of June.
So it's reasonable that he didn't have notice of this when he actually when he actually determined when his vacation would be. So I don't think that that's unreasonable. However, as far as waiting until this matter is over, the stay of appeal is related to the board, and I would have to research the stay while the appeal is pending. I'd have to research the issue. I see some questions already in the cert, but I just haven't had time to research the full procedure.
So would it be your recommendation then that we
Bring
Wait,
it back 30
bring it back
days.
next month?
Yes, sir.
I'll make a motion to continue this to
fine.
the next meeting next month, which, do I need the date in the?
Yes, please. In the meantime, we'll get this, I'll move this along as quickly as I can, but as a special writ, there's procedures that have to be followed, and I'll make sure those are followed in the meantime.
It'll be August 7th.
I'll make a motion, we continue this to the August 7th meeting of the Competency Board.
We have a second, motion is second. Any discussion? All in favor, raise your right hand. All opposed, same sign. Seeing none, hearing none, motion is approved.
Thank you, Board.
Thanks. Okay. Is there any new business we need to discuss?
Not necessarily new business. All of you should have received an email from me in regard to the county ordinance. Christy and I are currently undertaking fixing some things, adding some things, So I sent to all of you the section related to disciplinary for your review and for any commentary on that.
And they can respond by email?
That's correct. You can respond
deal.
back to me via email.
Okay. All right. Everybody receive that?
Yes.
Good
It's a
deal.
pretty big revision.
It is, yeah.
Thank you, we're aware of that.
Yes, yes. We are doing Chapter 18 as a whole related to construction.
All
The only
right.
thing we don't have to touch is the Florida Building Code.
Yeah, that's
Yeah.
good.
We already
Leave
did
to
that.
Mr.
We already
Tim.
did that.
Leave that to Mr. Tim and his crew. Okay, if nothing else here, meeting is adjourned. Thank you,
you.
guys. And ladies.